Okay? I am not an attorney who makes civil actions or against opposing counsel for fraud. That's something that I don't do, and I wasn't hired to do that, and I have told you that. Just because you hired me and paid me some money, not all, does not mean that you have license to make me do anything and everything legally for you. That's not what our contract says.
I do have the contract.
I have a contract. I have a copy of it too.
Okay.
And you cannot make me do everything that you say.
But
I'm sorry,
by
Manny,
law,
but that's not how I operate. If we come to such a difference of an opinion,
look, I really don't care as long as you get it done. If you don't have
confidence in my behavior and my advice to you, then I can withdraw.
At this point,
no, I can't represent you. I try to withdraw. You were so adamant that
even
you
the
thought I
judge
wasn't
said so.
doing anything.
Even the judge said so at this point, right?
Said what?
You cannot step out of it
Said,
now.
I don't want you to leave, Miss Lee. I don't want you to leave because I don't think we're going to be able to get this done without you.
Look, we
are here to discuss this because you're telling me you're going to sue everyone.
Okay. Look, as I said also to your guys at the office, okay, I don't want to do this. Okay? I do not. I wanted to get this to be done.
Okay.
So they cannot provide anything. So what are we going to do? What are you going to do? They cannot provide any proof of...
What am I going to do? Right. Just a minute. You are correct. I understand your arguments, and you have given me a lot of evidence. If you will allow me to do so, I will present all of it to the court. Okay?
When?
So there are two things that I have to do. Two things. One is to draft a motion to get credits for the overpayment from the amended quadro based on the accounting from DFAS showing that you paid more than your share, than your obligation. Okay? That's the first thing. We already have pending a claim for fees and costs. You have given me a bill that includes all of your living expenses for the past 2.5 years to stay here. I don't think the judge is going to give you that because you would have had to pay to live anyway. And all of the hearings have been by remote appearance. So I just don't see how the judge is going to give that to you. But I'll make that claim, okay? I have reserved on fees and costs, okay? Otherwise, I included every little bill that you paid, all of the repairs, maintenance items that you paid, and the other stuff is just math. Did you overpay your support obligation? Yes. Can we prove that? Yes. Did she receive a little bit more money than the mortgage, interest, insurance, and tax payment? Yes. There's a little bit extra there too. Were you obligated, if there were necessary repairs, were you obligated to share part of that? Yes. That's the way that the order is worded.
Which order?
At the end of the day, when the place is sold, the judge would require that she give an accounting, and if there were extraordinary repairs and maintenance items that exceeded the amount of rent, that you would have to share with that or it would come off the top. That's how they're going to divide it. That's how it's worded. Can I prove these things? Yes, I can prove from your end and some from her end. And I've demanded actual proof of payment, and you have the pictures to show that this work wasn't done or that the costs were astronomical, and probably not paid, that it was fraudulent, that she's lying. I can bring all of those arguments, and I plan on doing so.
Okay.
That when you tell me I have to sue Phillips for fraud, I'm sorry. I was not retained to do that. It's not my area of practice, and I'm not in that case. That's a different, would have to be a different case, not this case. This case is, did your ex-wife lie? And yes, I'll bring that up. Did she fail to provide proof? Yes, she has. Did she mismanage all of this accounting and miss deadlines and all of that? Yes, I will bring that up. Did she cause you to incur additional attorney's fees and costs because of her behavior? Yes, she did. So will I bring all of that up? Yes, I will. Okay? So my next step is to do what I was retained to do. After he fails to provide me with the additional receipts, I have to make the motion, schedule the hearing. And you probably need a couple of hours. This is not a 1-hour hearing.
Okay.
That's my plan.
Okay. When this gonna happen?
And I have given you an update.
Okay.
Today the courts are closed. It's Martin Luther King Day.
Okay.
So you're not going to get a hearing date today.
Okay.
I can probably get the motion filed this week and the hearing scheduled.
Okay. You're gonna file, because that's another thing, you know, that I really encountered in all this, that you said that you do and eventually you don't do. I like for you, okay, and I need at this point, okay, to expedite this as quick as possible, because they're stolen, okay, and I know they're stolen. You know they're stolen because they don't have anything. They presented a set of bills. They backed off those bills, but you know what? That's fraudulent. And that was the intent of that, because those bills that they presented, you know, we had to wait. I had to wait 2.5 years, and still it's not over yet. Now they're changing, they're presenting, they're changing, they modify. You know, what are we waiting for? I need to put a stop at this, or this is gonna go on forever. And as far as I understand, this is not anymore. It's a litigation. And in a litigation, whatever you litigated for, if you're presenting, you know, fake bills or something that you cannot prove, that is the intent of the fraud. Okay? Something else that, you know, that I can think of is Mr. Phillips for sure knew all this. When he came to court and he said, you know, there is no other lease. And I gave you the other lease. He sent it to me. She sent it to him, carbon copy to me. He knew that. But he went.
Me. I think I only have one lease.
I sent you
I have one
two
lease.
leases. 2 leases. One is it expired in 2009, October 2009. The first one. Okay, we had the court. No, it was October 2009. We went to court in 2010, and she didn't have a lease.
I have a 1-year lease in 2008,
right,
and another lease from 2011. And I have the transcript that said that she said around 1,300. The 2008 lease was 1,250. The 2011 lease is 1,250 also, and then she said 1,300 in her testimony, and he tried to calculate it at 1,100.
Right. Now tell me, he comes to court and he says that the transcript.
No, he's not going to, because I told him it was not true.
He knew that was not 1,100. He knew that it was not 1,100. He knew.
And
so that's
go
where
ahead,
my point
and
is.
I hope he tries, because yes, I'll bring it up. But he backed off on that.
Well, too late to back off now, because you said, you know, we have proof that of this and that, but
That's
he tried to
grounds
deceive the court.
That's grounds for you to have a fee claim. The fact that he should have known that he provided the lease, that we could calculate it, or actually Rookie had the lease and knew and has refused to give any other leases. I mean, that's grounds for you to make a fee claim, but not for me to scream and yell that the attorney committed fraud.
What is he doing? Maybe I don't know that much about the technicality of how to apply these rules and regulations, norms, and laws.
Okay.
Why would
sorry,
you classify?
Danny,
Why would you classify that?
Okay, let me finish a minute.
Go ahead.
Danny,
Yes.
I understand that you have been screwed. I understand. I am passionate that you have been given a horrible deal in this. But I know that sometimes you've been your own worst enemy. You have made, I mean, you've recused judges, you've screamed and yelled at judges, you've accused all the other attorneys of fraud and criminal conduct and all of this stuff. And, I'm not sure how things go in Italy, but I know that here you're not going to get really far. Whether that's right or wrong, I can't judge. It's the case. It's the situation that I'm dealt with. Every attorney is obligated to represent their own client zealously, and unless they ask